their original grievance is that no facility is being extended to them and their condition is very precarious.
No.
In these circumstances, my lord, the state government.
What they are seeking is, we are regular employees. You treat us as a regular force, give us all the benefits that you give to a regular force. You are saying no. You are a voluntary service. You are volunteering to work. So where is the question of a regular force?
My lord, now they are getting the minimum of pay scale to a constable, that is 29,000 rupees, 29,140 rupees. They are getting the minimum pay as on date, my lord.
Are they regular employees?
No, they are not the regular employees, but they are getting the minimum pay of a constable post.
That's because of the orders of the court.
Yes, sir.
Please tell us, on what basis do you say that they are not a regular force or a regular employee? What is the
because it is the act and the rules, my lord, which is having the preamblance, my lord, that their induction is only on the basis of the need of the hour, my lord, and the state government or the district magistrate is having the.
Please tell us, in this 36 months, how do you know that 2 months we don't require them?
My lord, what has happened, my lord? Initially,
Please tell us.
Yes, my lord.
In last, say, 10 years, how many days have you not needed a home guard at all in the imports?
My lord, that condition has been arisen due to the circumstances, my lord, because initially there was. My lord, what has happened, my lord? There is no recruitment from last 8 to 10 years, my lord.
All right, forget about 10 years, 20 years.
20 years, my lord.
In 20 years, how many days have you said that today not a single home guard is required on duty?
My lord, up
Has
to
it
90.
ever happened?
No, my lord. Up to
That
90.
means it is a perennial requirement?
Yes, my lord. It's a requirement as on date, my lord. There is no issue to that, my lord. But 90, my lord, what has happened, my lord? The original act says, my lord, that up to 90%, my lord, the deployment can be made, and subject to permission of the state government, even the 100% deployment could have been made. This is the provision under the act itself. So if the state government is of the view, my lord, that their services are required for throughout the year, my lord, then they can do it. In fact, my lord, initially up to 1990, this was the requirement wherein the state government.
90% of the strength or 90%?
90% of the strength, total strength. So, my lord, up to 1990, my lord, they have been employed for 6 months. From 1990 to up to 22, my lord, they have been employed for 10 months.
Mr. Ganguly, you can say I have a force of 10,000. At a point of time, by rotation, I will employ 9,000. 1,000 will be on leave all the time. That's an artificial break.
Yeah.
But if you say in 365 days, in the month of June, I don't need anybody, then you could be right. That I don't need anybody for a month, call of duty for that month, because, for example, let's say the court premises. In June, the court is closed. There's nothing happening. Or an institution is closed for a month, nothing happening. Or supposing you have an exhibition ground where you have exhibition 6 months in a year. You say for 6 months when the exhibition is there, I need guards. So I will employ these guards for that 6 months there. And 6 months, since there is no exhibition, they're called off duty. That is not happening for them. For them, by rotation, to overcome the law that you need to regularize them, to give them salary, you say, I need 3,000 throughout the year, so I'll employ 4,000. And 1,000 I'll keep laying off out of those 3,000 and create an artificial that and say, no, I don't need you perennially, call off duty. That is not the correct position. If they are required, if the work is there 24/7, 365 days a year, then you can't follow them.
As a regular, yes, may not cancel.
One case in the return, they have admitted that they are continuously working since 2011.
We see them every day.
Yes.
You see them every day. You are rotating the numbers. You are
Yes,
not rotating the days not required.
Maran, what has happened, Maran? In fact, this is my humble submission is that this is the assessment made by the state government time to time. As I have already said, Maran, that up to 1990, it was 6 months in a year. Thereafter, when there is a requirement, then it is 10 months in a year. And now it is 3 years. So, Maran, the state government is vigilant.
This question is not that. 6 months or 10 months in a year, for the remaining 2 months, did you need home guards or you didn't need home guards at all? In these people, are they called off on duty on one day and after 2 months they get back? In 36, in a block of 3 years, Is it a fixed 2 month period or people are rotated for 2 months?
People are rotated for 2 months.
That means what? That you're artificially creating this break. If you don't
The
need that
department
work
needed
for-
their service, my lord.
If you don't need that work for 2 months, one can understand. That we have a 34-month cycle. For 2 months, nothing is happening. Everybody is off for 2 months.
But my lord, there is a requirement which is fluctuating from time to time. Looking to that requirement, my lord, the 10% question is there, my lord.
Why 34 months? And requirement what? That means you are overstaffed. If you have, say, a strength of 20,000 home guards, you require 34 out of 36 is what, about say 8,000 you require. You should have a sanction strength of 8,000 regular employees. You can't have 10,000 and keep rotating.
My lord,
Why? All right. Why not in the police? Have 20% extra and rotate them every 3 months. Don't have a regular police force.
my lord, my submission is that even if, as the state government was vigilant about these aspects, my lord, so time to time, my lord, the appropriate amendments have been made. So my submission is that once the initial 6 months has been transfused to 10 months in a year, then 34 months in 3 years, my lord. So it is the state government, my lord, based upon.
Is there,
Yes, sir.
you saying based on some census or something, show us what is the rationale? Why this decision was taken to make it 6 months, then 10 months in a year, then 36 months in, 34 months in 3 years. So there must be some record. What is the basis? Or suddenly somebody said, let's do it 34 months. Why 34? Why not 33 or 35? Must be some record.
Yes, my lord,
Where is that?
My lord, I'll call that report, my lord, if not so.
Two things.
Yes.
Voluntariness. That means today I don't want to come to duty. No penalty, no sanction. You can't force me to come. It's voluntary. If you can force him to come or subject him to discipline for not reporting, then voluntariness goes. Yes, once reported, then bound by your rules and regulations. That is one. Secondly, what is the reason for restricting this period and not making it 365, 24/7? That you have to show us. That's the only issue here.
My lord, if they are not pressing upon the aspect of being declared as a civil post holder or become a regularization, because this issue has been settled in various judgments, my lord.
That will
I'll cite.
automatically
If
be
the
consequence.
issue is only call of 34, if they are,
That will be
because
the
there are challenges to other aspects also, man.
Mr. Ganguly, that will be the consequence. Moment we hold this is not voluntary and your artificial creation of 2 months
That
goes,
goes automatically.
then
Yes,
they become a regular force.
yes.
Or disband everybody and send them home. Then run your administration. You won't be able to. How many home guards are there? How many are there in
My
the
lord,
state?
my lord, in approximately 9,000.
Without minus these 9,000, can you function on a daily, day-to-day basis?
No.
You will not. That's the problem. You have to be alive to the situation, take them on.
My lord, as per my information, 30,000.
30.
Yes, my lord.
No.
That is what. Please.
Total sanction code, total sanction code are 16,000 and they are working less than 10,000.
What is their stand?
That is your decision. If you don't want to, you may sanction, not sanction. If you don't require, of course, we can't force you to have that many numbers. It's up to you. If you have 10,000 working, you see, you can't function without them. You're taking service 24/7, 365 days by rotation. Then it becomes a regular force. Their grievance is not to declare us the argument that declare us a civil post is only for the purpose of give us a regular appointment.
That is what.
365.
Our submission is.
Of
Yes.
365 days
That
in
is
a
what.
year.
And treat us as a regular employee and give us all benefits.
1950s.
47, my lord.
The certificate.
That has been considered by, that judgment has been considered and it has been negated. That judgment has been considered by the single bench in Justice Aaron Malot, and there is. Yes. Consider, Malot, may kindly come to that part, Malot. Yes, Malot.
Yes.
Malot, the judgment has been quoted, Malot.
Has been stopped, my lord, in such judgment.
Please show us what was the division bench order. Let's see.
Malot, para 11 is the judgment, Malot. Para, 55 judgment has been considered, Malot. And
Not
there-
considered, my lord. It is mentioned only, but not considered.
That is about the civil post, my lord. It is not being,
1955 judgment.
Yes,
So
not-
it is mentioned, but it's not considered.
SNPA.
And that is DB judgment could not have considered.
yes.
It have been overlooked. 1955 judgment was covered by the DB. It could not have been overruled by the single bench.
But para 14, it has been considered. Para 11, it has been quoted, and para 14, emphasizing that the judgment rendered by the Nagpur High Court in Sher Singh so and so was based upon the benefit to be granted and the protection available under Article 311 of the Constitution of India. It is without referring to the statutory provisions of the Act. The same is no more a good law in view of the subsequent judgment rendered by this court, particularly in the case of so and so, so and so, so and so, so and so. Then Advocate General submits that the contention of the petitioner that they are the civil post holder cannot be accepted, and thereafter this matter was further. Para 19, 20, 21 are important, Marat. Para 19. Having heard the learned counsel for the parties at length and after taking note of the various contention advanced at the time of hearing and further on the close scrutiny of the report submitted by the State Human Rights Commission, the matter is being decided. As far as the claim of the petitioner for treating them as a civil post holder and further issuing a direction for treating them as a regular employee of the department are concerned, the same is to be considered in the light of submission made by Shri so and so, particularly with reference to the right and power of the Human Rights Commission, in the light of the principle laid down by the Supreme Court in the case of so and so, relied by so and so. This court cannot issue a mandamus for implementation.
And Supreme Court simply upheld that.
So no mandamus can be issued, Marat.
Yes, वाले को जजमेंट है, इसी में से जजमेंट में अपने अनुच्छेद रिटर्न में लगाया है इसने, इसीलिए स्टेट गवर्नमेंट ने इस जवाब में अपनी केस में इसमें विभिन्न जो समस्या में
Pending है. This appointment business thing is mentioned.
high level
The whole judgment is intact.
yes going to be this one.
Marat, just one judgment may be seen, Marat, that is in reference number 14. Marat, this is by the Honorable Supreme Court, Marat. Marat, sir, civil appeal number 6373 of 2010, Marat. It has been decided on 10th of March 2015.
No, this is parity with the police constable.
Police constable, my lord, even the MP Home Guard Act 1947 and other states have also been considered, my lord. That is para 19.
para 19 report कौन सी जजमेंट की बता रहे
His judgment. Our act is not considered.
Well,
Well, yes, let. देख लो 16 victims.
This one. This one. Para 90.
You see, if you look at para 28 of that judgment, over the years, situation has changed.
Yes, ma'am.
In 1947, when it was created, it was a completely voluntary force, where the people who were employed other places could come and take up. That's what it says. In fact, government servants were also enrolled as home guards to be called as and when the need arises. Can today a home guard get employed somewhere else?
My submission is that
16.
looking to the nature of requirement as on date, my lord,
90.
this decision was taken that is now in 3 years, my lord, only 32 months break will be
Because
there.
what is the rationale of that decision?
Yes, ma'am.
Show that reasoning. Produce the minutes of that meeting which took that decision. We'll consider it. There is a rationale. Well,
21.
19 group अगर हम करें
कौन से कोर्ट 90?
मतलब in this context मतलब 2003 West Bengal was there. This is the case मतलब on the home guards there.
And if they are not, my lord, if they are not, if they are not pressing upon these other aspects, my lord, except 2 months, my lord, then the state government can be directed, my lord, at least to reconsider the entire matter, my lord. With
This is
regard to
about
their
Panta
those 2 months.
Chatterjee's case, my lord, which
yes,
is.
sir. Are you willing to give up that prayer?
No, remaining prayer, my lord, with regard to civil post holder, my lord, there is already a decision.
If
Regularization, there is already a decision. So at least, my lord, with their, as per their recruitment, as per the preamblance of the act, only call off aspect is, my lord, what has happened, my lord, all these matters were listed before the honorable.